Good morning, everyone. We are almost halfway through the class, believe it or not. Kind of scary, kind of cool, all at the same time. This lecture doesn't really have technical stuff like the last couple of well, actually all of them that lead up to now. For example, we're not really going to talk about a specific tool. We're not really going to talk about acquiring information with regards of like using volatility. For example, what this chapter focuses on is the legal system. It's all about the legal system, some cases, the amendments, and various laws that you should be familiar with. And now at first, that may seem boring, but let's see what you think by the time we're done through this. Sound good? Cool. So let's begin. All cases are tried per their state and the federal laws. A jury is a group of people put under oath to hear arguments at a trial and render a verdict of guilty or not guilty. The plaintiff is the person who initiates the lawsuit and is responsible for the cost of the litigation. The defendant is the person who defends himself in a lawsuit. The origins of the US legal system. There are three ways that we have the common law that is based on case law and precedent with laws derived from court decisions. Precedent is court decisions that are binding on future decisions in a particular jurisdiction. Therefore, these laws are derived not from legislation, but from court decisions. Civil law is based on the Napoleonic Code, which is also based on Roman law. Civil law is based on scholarly research, which becomes legal code and is enacted by a legislature without precedent. The three primary bodies of law exist in the US: constitutional law, statutory law, and regulatory law. The constitutional, or the federal law, outlines relationship between the three federal branches while protecting the rights of its citizens. Statutory law is written law from legislature at national, state, or local levels. These are codified, which means statutes that are organized by subject matter, and uncodified laws. Regulatory law governs the activities of government administrative agencies, such as tribunals, commissions, boards responsible for decision-making that affect the environment, taxation, international trade, immigration, and so on. Understanding the structure of the court system provides better understanding the rationale for cases being tried in a federal versus a state or a county court. The basic structure of federal, state, and local courts is all the same. A defendant has the right to a fair trial with the outcome determined by a jury of his peers. The role of the judge is to facilitate the trial process and ensure that the proceedings are in accordance with the law, along with ensuring that the proceedings are free of prejudice and the innocence of the defendant is presumed until proven otherwise. the burden of proof is always on the prosecution. Here we have a picture of the structure. We have appeals courts. These courts enable its citizens to appeal a conviction, deciding whether to hear an appeal. Appeals are not trials. A panel of judges renders a decision whether a mistake occurred in a lower court. The federal courts, they derive of Article 3 of the Constitution. They consist of the district courts, the circuit courts of appeal, and the US Supreme Court. Two other types of Article 3 are the US Court of Claims and Court of International Trade. These do not have a general jurisdiction or a scope of legal authority granted to an entity. There is the Supreme Court. Under Article 3, the president is responsible for appointing federal judges, subject to approval of the Senate. The appointment is for life unless removed by impeachment. The judiciary branch is the ultimate arbiter of the law, not Congress or the president. Article 2 of the Constitution outlines the jurisdiction of the Supreme Court and other federal courts. And that section reads, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and a citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. The Federal Appellate Court. There are 13 circuit courts of appeals established in the original states. There are 12 regional circuit courts, as well as the additional federal court in DC. Each of these is assigned a circuit justice from the Supreme Court. These courts can refer cases to the US Supreme Court, with 3 judges sitting in each of the 13. We have US district courts. There are 94 US district courts across the United States. Each state has at least one. Most federal cases, criminal or civil, begin at the district court. Kidnapping or intellectual property cases are some examples of cases tried at a district court. State courts vary at each state. Local trial courts are located throughout the state and hear cases at lower levels. If a defendant is found guilty, they can appeal a conviction in the state appellate court. State appellate courts are often referred to as the Supreme Courts or the Courts of Appeal. These are the highest courts in the state judicial system. They have discretion over which cases they hear and are often referred cases when there could be an error in determining the law. They are confined to a particular jurisdiction and asked to preside over contentious decisions, like elections. 3 to 9 judges sit on these panels. We also have the intermediate appellate courts. These exist in 40 of the 50 states. The ones who don't have an intermediate appellate court are Delaware, Maine, Montana, Nevada, New Hampshire, Rhode Island, South Dakota, Vermont, West Virginia, and Wyoming. They have various number of judges in each state. There are also trial courts of limited jurisdiction. There are the probate, otherwise known as the surrogate court, hearing cases related to distribution of a deceased assets. There's the family court, which is like child custody, visitation, support cases, and restraining orders. There's traffic for all driving violations. DUI, DWI are crimes tried in criminal courts in many jurisdictions. The juvenile, where minors are tried by tribunal. The small claims settles private disputes involving small monetary amounts. And municipal, cases where crimes are tried within their jurisdiction. There are trial courts of general jurisdiction. These can hear any kind of criminal or civil case that is not exclusive to another court. For example, in New York, there are a couple of different trial courts. There's the trial by jury, which is the Supreme New York City Council or New York City Criminal. Outside New York, New York City, you have the Supreme, the county, the district, city, town, and village courts. And within them, you still have the attorneys or the counsel, the court reporter, the county clerk, court officer, the defendant, the interpreter, the jury, the plaintiff, the prosecutor, spectators, and witnesses. In most of these, there is a pre-trial and trial process that is pretty much the same. You have the jury selection, the oath and preliminary instructions, the opening statements, the testimony of witness and presentation of other evidence, closing arguments, jury instructions, deliberations, verdict, and sentencing. The right by trial by jury is outlined in the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime has been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory processes for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. There is an actual term for the process of selecting the jury. Lawyers and judges can ask potential jurors questions for any biases that could influence their impartiality in the case. All defendants are presumed innocent until proven guilty beyond reasonable doubt. Different type of courts will have different amount of jurors. Some cases require the jurors to be sequestered or isolated to prevent external influences on jury decisions. Contempt of court means violating the rules of the court procedure. The foreperson is the first juror seated and is ultimately responsible for reporting the verdict to the judge. During a criminal trial, the prosecution will go first, since they have the burden of proof and must prove guilt. The defense must not prove anything. Under the Fifth Amendment, the defendant need not speak ever in the trial. Direct examination is questioning counsel's witness in a trial. A cross-examination is the questioning of the opposing side's witness in a trial. In regards to verdicts, deliberations is the process where the jury reviews the evidence and discusses opinions about the case. A hung jury occurs when the jury cannot come to a unanimous decision and a retrial must occur. This is not necessary in a civil trial. The jury also decides how much money will be issued in a civil trial. It is responsibility of the judge to determine the sentence. Criminal charges are initiated by government prosecutors on behalf of the people. The defendant is indicted to stand trial and answer questions relating to serious crimes or provide information. A felony is a serious crime and generally carries a penalty of 1 or more years in prison. A misdemeanor is a less serious crime with a possible sentence of less than a year. A deposition, a sworn witness testimony taken during the discovery phase, which is prior to the trial, is generally not taken for criminal cases. Civil cases can be presented with them. A civil case is brought by an individual or organization, referred as a plaintiff, against an individual or an organization. Civil trials generally dispute over money. If successful, the plaintiff is awarded money by the jury. A civil trial identifies whether an entity failed to act reasonably and prudently under a certain set of circumstances, or what's known as the preponderance of the evidence. Or most of the evidence presented indicates which party was in the right or in the wrong. Okay, so now we're going to switch gears from the court system in the various courts to some laws. And I have some questions for you here and there. Whoops, I am missing a slide for the First Amendment. Anyway, the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the peoples peaceably to assemble and to petition the government for a redress of grievances. Though this was written long before digital communications, we rely on the Supreme Court and other lower federal courts to interpret what protections a person posting insulting comments has, along with the rights of the victim. Can any opinion, no matter how disturbing, be posted on a blog? Is that covered under the First Amendment? Do you think it's covered under the First Amendment? Okay, see some no's. With the First Amendment, there is sometimes a difference between moral responsibility and constitutional law. In the notes, in the lecture notes, I have some cases. You don't have to read them, but if you are interested in, there are some to read. For example, there was a case of a person versus a school district over a posting on MySpace. There's a landmark case that predates the internet that has been used. Tinker versus Des Moines Independent Community School District, along with a few others. The Fourth Amendment. The Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment protects people, not places. One of the issues that arises with the Fourth Amendment is the expectation of privacy. A link clearly exists between unreasonable search and seizure and the expectation of privacy. But the Supreme Court has not always been clear about the linkage, which causes confusion, and case law is the best guide for litigators. For example, one gray area is expectation of privacy in the workplace. A few other terms under this amendment are the exclusionary rule. Evidence seized and examined without a warrant or in violation of an individual's rights will often be inadmissible as evidence in court in a criminal case. There is fruit of the poisonous tree, a metaphorical expression to describe evidence that was initially acquired illegally. All evidence subsequently gathered at every point from that initial search is inadmissible in court. This is why I've been harping so much on your chain of custody and documenting everything and making sure you have every little step written down because of that specific one. Certiorari is the order made by a higher court that directs a lower court or a tribunal to send it court documents related to a case for further review. And there's motion in liming, request by a lawyer to hold a hearing before a trial in effort to suppress evidence. Next, we have search warrants, all within the Fourth Amendment. This is arguably the most important part of the Constitution for forensics investigators. Law enforcement must obtain a search warrant, a court order issued by a judge or magistrate, authorizing law enforcement to search a person or place, as well as seize items or information within the parameters of the warrant, before a search can be carried out. Investigators must demonstrate probable cause, which is the conditions under which law enforcement may obtain a warrant for a search or arrest when it is evident that a crime has been committed. Warrants are specific to a particular crime and criminal investigation. They are specific to a geographical location. For example, if a house borders 2 counties, 2 separate warrants are necessary to search the entire property. In one case, law enforcement was issued a warrant to search a house, but the suspect's computer was located in a shed in the back of the house, which was not in the warrant, and thus not permitted to be seized. Here's a different question that a presenter at HCCIA asked the group. If you were to be searched and you had to pick one of the two, what would you pick? Would you allow law enforcement to search your home or your cell phone? If you had to pick on which of the two you would get searched by law enforcement, would you allow law enforcement to search your home or search your cell phone? Funny enough, it's funny, when the presenter was talking about that, was that we're supposed to be more defendant of our home than our cell phone. But we have, as a society, we have changed our view on what is more precious. Our home should be the one that we pick every time, not our cell phone. But we've put so much personal value into the cell phone that we're forgetting the law that says that our home is supposed to be protected. Now, there is such a thing as a warrantless search. Not all searches require a search warrant. Since the Patriot Act, law enforcement has greater powers, extending warrantless searches when a person's life or safety may be in danger. The DOJ has guidelines for warrantless search and seizure of computers. When appropriate consent is given or granted to a government agent, a warrant is not required. Consent can be granted when an individual waives his or her Fourth Amendment rights. The search is limited to the physical area of the individual's authority and to a specific criminal investigation. A warrantless search is also subject to the totality of circumstances. An individual granting consent must be of sound mind, must be an adult, must be educated with a certain degree of intelligence. Sometimes law enforcement uses the knock and talk, as shown on this left side. Without sufficient evidence, or they cannot prove, or they cannot demonstrate probable cause to enter a residence search, to execute a search, law enforcement can go to the suspect's home and try to obtain that consent of the individual in order to get entry to the home and conduct the consensual search. Which is why I found this and found it funny. So knock and talk They just go up to the person. They don't have sufficient evidence. They don't have any way to prove probable cause, but if they can get the person in there's consent, then they can walk in. The plain view doctrine, which is this little GIF from Archer, allows government agents to seize evidence without a warrant when the officer can clearly observe contraband. The officer must be lawfully present in an area protected by the Fourth Amendment. The evidence must be in plain view, and the officer must immediately identify the item as contraband without further intrusion. Search warrants never allow investigators to conduct a general search. One more time. Search warrants never allow investigators to conduct a general search. It is always specific. I have a few more terms. There is plain error. Appeals court identifies a major mistake made in court proceedings, even though no objection was made during the initial trial in which judgment was passed and a new trial was ordered. There's the rules of criminal procedure, protocols for how criminal proceedings in a federal court should be conducted. There's the search incident to lawful arrest, allows law enforcement to conduct a warrantless search after an arrest has been made. And there's standing, a suspect's right to object to a Fourth Amendment search. To your question, James, if a body camera catches evidence at the door but no consent, would that be dismissed? The officer has to be the one to see it, not so much the camera. From that point, then I would leave it to the attorneys to debate it out. But from my understanding is the officer has to see it with their eyes and see it immediately and identify it immediately as contraband in order for it to be seized. So here's a question for you. When does digital surveillance become a search? A stingray is a generic name for a device that acts like a cell phone tower to locate criminal suspects, but can also locate people in disaster areas, such as earthquakes. A pen register is an electronic device that captures telephone numbers. These require law enforcement to show only that information retrieved is likely to assist in an ongoing investigation. Pen registers are not searches. In Smith versus Maryland, the DOJ admitted it conducted a search, but contended that there is no expectation of privacy when using a cell phone. The prosecution stated that a court order issued by a court and detailed set of steps to be carried out by law enforcement did allow investigators to capture real-time data from Verizon. Yeah, people are making stingrays with Raspberry Pis now. You don't need probable cause to make a stingray. What about GPS tracking? GPS tracking devices are prevalent and widespread with their legality in the fore. For example, it is not illegal for law enforcement to attach a GPS tracker if the area does not pass the Dunn test for curtilage, which is an enclosed, intimate space. I'm going to read two quotes from two different cases. This first one is US versus Knotts. Monitoring signals on these devices does not invade any legitimate expectation of privacy on the respondent's part. And thus, there was neither a search nor a seizure with contemplation of the Fourth Amendment. The surveillance amounted principally to following an automobile on public streets and highways. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements. US versus MacIver has an interesting quote. The undercarriage is part of the car's exterior, and such, it is not afforded a reasonable expectation of privacy. In other words, if your car is parked on the street, if your car is on the road, if your car is parked in an area that is not closed off like a garage or behind a fence, then it is perfectly legal for law enforcement to walk up to your car and stick a GPS tracker in the undercarriage. Yes, Austin, you are exactly correct. When you put your trash out on the street, it is no longer private trash. Absolutely right. Where is the legality if this has been done, but the car is parked in the garage after? Well, it was after. If the car, yeah, at the time that law enforcement stuck the GPS tracker on the vehicle, if at that time it did not pass the curtilage test, that it wasn't in an enclosed intimate space, then they can walk up to it and stick a GPS tracker. And like that one, the first quote that I said, you could be in a public place. So it's not necessarily saying that anybody paranoid listening to this will go, okay, I want to put my car in behind a fence or in the garage. Well, you're gonna take it out eventually. You're gonna go to like the grocery store. You're gonna go somewhere public with it, and it's at those times that they could walk up and stick the tracker. Sell the car and go Uber. Oh, that's funny. Traffic stops. This is the last thing in the Fourth Amendment. In the case of Riley versus California, the US Supreme Court ruled in 2014 that police require a warrant to search the cell phone of somebody who is arrested. This was a landmark decision for law enforcement and forensic investigators because a cell phone can no longer be searched incident to arrest. So if somebody is arrested, that does not mean it is legal for that officer to begin searching their cell phone. I forgot I had those pictures. Well, being that everything has been specific, my thinking is that would apply to just a cell phone. Okay. The Fifth Amendment. The Fifth Amendment reads, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This amendment protects the individual from self-incrimination. A defendant is not compelled to testify at a trial and may plead the fifth. An indictment is a charge delivered by a grand jury, which is a relatively large jury that determines whether conditions exist for criminal prosecution, stating the accused must stand trial. Investigators must be sure to have gathered all necessary evidence before the case goes to trial. This amendment does influence the outcome of computer forensic investigators. For example, forcing a defendant to supply a password is forcing the defendant to provide testimony because the defendant is conveying his knowledge, like a known password or a PIN, to access files within an incriminating device. Conversely, a suspect can be forced to use his finger to unlock a laptop or smartphone. Biometric access is not protected by the Constitution. Face ID is not protected by the Constitution. If you have a biometric unlock feature on your phone, law enforcement can legally force you to unlock it. Pause for effect. But yes, if you have biometrics, law enforcement can force you to unlock. Only by PIN or password can law enforcement not force you to unlock. And I know that isn't the most ideal thing. PIN and password isn't always convenient, but it is protected under the Constitution. So that is a decision for you to make on your personal self. If you want to stop using biometrics, because should you ever get into hot water with the law, then they can't force you to unlock your laptop or your cell phone. Oh, I got one more. Sorry. Sixth Amendment. Sixth Amendment reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by impartial jury, the state and district wherein the crime shall be committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted by the witness against them, to have compulsory process for obtaining witness in his favor, and to have assistance of counsel for his defense. The Sixth Amendment does not impact computer forensics investigators and law enforcement very frequently, but it's important to acknowledge, because of the confrontation clause in all criminal prosecutions, the accused shall enjoy the right to be confronted. The investigators are forced to appear in person. So if you work on a case, the Sixth Amendment basically says, because you worked on it, you're gonna show up. You're gonna go to the court. Okay, now we'll move on from the amendments to other congressional legislation. Starting with the Federal Wiretap Act. This section prohibits the unauthorized interception, disclosure, and use of wire, oral, or electronic communications. The prohibitions are absolute, subject only to the specific exemption in Title III. Consequently, unless an interception is specifically authorized, it is impermissible, and assuming existence of the requisite criminal intent in violation of this section. This law states, law enforcement is prohibited from using wiretap without a judge's permission. A wiretap is authorized by the Justice Department, signed off by the U.S. District Court or the Court of Appeals judge, and valid for 30 days. Under this law, service carriers may, on occasion, monitor and intercept communications to combat fraud and theft of services. This law has been amended by the Electronic Communications Privacy Act of 1986 to include transmissions from a computer. The Stored Communications Act says there are no Fourth Amendment protections when using an ISP, an internet service provider, or an email provider. You have no Fourth Amendment rights or Fourth Amendment protections when using an ISP or an email provider. Stored communications is defined as any temporary intermediate storage of a wire or electronic communications incidental to the electronic transmission thereof, and any storage of such communication by an electronic communication service for purposes of backup protection of such communication. Applying the Stored Communications Act is problematic, since law enforcement operating in one jurisdiction is granted a search warrant, but a service provider is headquartered elsewhere, with the actual servers in a different location. Through rulings based on this law, there should be a diminished expectation of digital privacy in the workplace. The Foreign Intelligence Surveillance Act. This act outlines procedures by which electronic surveillance may be carried out to protect U.S. from international espionage. The act was amended by the Patriot Act to include terrorism in the scope, which may not be state-sponsored. The use of pen registers and trap and trace devices in foreign intelligence investigations is in this section. The Computer Fraud and Abuse Act. This law invokes stiff penalties for those found guilty of unauthorized access to a network. Section 814 of the Patriot Act made several amendments, such as increasing the maximum penalty to hackers who damage computers to 20 years in prison, include intent to damage a computer rather than the type of damage, and new offense for damaging computers used for national security or criminal justice. Corporate espionage has its own law. Having knowingly accessed a computer without authorization or exceeding authorized access, and by means of such conduct, having obtained information that has been determined by the government pursuant to an executive order or statute, require protection against unauthorized disclosure for reasons of national defense or foreign relations, or any restricted data, as defined in the paragraphs Y, section 11 of the Atomic Energy Act of 1954, with reason to believe that such information so obtained could be used to the injury of the United States or to the advantage of any foreign national, willfully communicates, delivers, transmits, or causes to be communicated, delivered, transmitted, or attempts to communicate. Basically, corporate espionage has its own law. Other provisions with all of those things have, like computer trespassing, committing fraud with a protected computer, distributing passwords of a government or a commercial computer, and damage to a protected computer. The Communications Assistance for Law Enforcement Act, telecom companies were forced to redesign their infrastructure to meet compliance with this law. Voice over Internet Protocol operators, or VoIP, are not subject to this law and might not be able to assist law enforcement with investigations because VoIP has no switches on a network and therefore provides a technological challenge for law enforcement using a Title III wiretap. There's no place for them to connect to. I've been talking about this law, and now it's time to actually talk about it. The USA Patriot Act. Born out of 9/11, it provides greater power to law enforcement to prevent terrorist acts from reoccurring. Law enforcement can conduct surveillance without judicial approval in certain circumstances. This law has affected digital forensics. For example, if law enforcement receives an email from someone who's been kidnapped, they can act without the use of a warrant because someone's life is in danger. Here are some sections of the US Patriot Act. Section 202 gives the authority to intercept voice communications in a computer hacking investigation. Section 209 says voice messages are no longer protected by the Fourth Amendment. Section 210 says subpoenas can include records of session times and durations, any temporarily assigned network address. They can obtain credit card and bank information for internet users. Also, it compels ISPs to provide complete details about incidents. Section 213 is also known as the sneak and peek warrant provision, able to search a home or business hastily without notifying the target in advance. It prevents a criminal suspect from tipping off other criminals about an imminent search. Section 216 extends pen registers and trap and trace statute to non-content information to the internet to include IP addresses, MAC addresses, port numbers, and user accounts. Section 217, an individual victim of unauthorized access by a hacker can allow law enforcement to intercept the communications of the trespasser. The user has the right to also intercept communications, but they have to meet 4 conditions. The owner or user of a protected computer must authorize the interception of communications. The person who intercepts the communication must be lawfully engaged in the ongoing investigation. Reasonable grounds to believe that the interception of a communication will assist in an ongoing investigation, and investigators must only intercept communications of the trespasser. Section 220 compels ISPs to hand over email records outside the jurisdiction of the investigation. Section 816 allowed the Attorney General to create regional computer forensics labs and continue supporting any existing labs. There's the protect or prosecutorial remedies and other tools to end the exploitation of children today. This act provides greater protection for children against abuse, eliminates waiting periods for law enforcement to begin investigating any missing persons 18 to 21, eliminates statutes of limitations for child abuse and kidnappings, and prohibit computer-generated child pornography. The Digital Millennium Copyright Act has 4 titles to it. Title 1 is the World Intellectual Property Organization, Copyright and Performance Phonograms Treaties Implementation Act of 1998. Title 2 is titled the Online Copyright Infringement Liability Limitation Act. It creates limitations on the liability of online service providers for copyright infringement when engaging in certain types of activities. Title 3 is the Computer Maintenance Competition Assurance Act. Creates an exemption for making a copy of a program by activating a computer for the purpose of maintenance or repair. And Title 4 has 6 miscellaneous provisions relating to the functions of the Copyright Office, distance education, exemptions in Copyright Act for libraries, making ephemeral recordings, any webcasting of sound recordings on the internet, and applicability of collective bargaining agreement obligations in the case of transfers of rights in motion pictures. DMCA is important for civil cases involving copyright infringement. These cases often involve subpoenas issued to service providers and expert witness testimony from investigators. Cloud, or Clarifying Lawful Overseas Use of Data Act, this federal legislation obliges US-based tech corporations to allow federal enforcement to obtain data stored on servers domestically and internationally without a subpoena, or with a subpoena or a warrant. This law hasn't been ratified by other countries like the EU. We have a few more sections. There's the rules for evidence admissibility. There is the Fry test based on Fry versus the United States. Expert opinion must be derived from a thing and must be based on science that is demonstrable and not experimental. The Daubert test based on Daubert versus Merrill Dow Pharmaceuticals. Computer forensic investigators must perform benchmark testing on their hardware and software tools. It enables the investigator to explain any known error rates. There's the federal rules of evidence that determines admissibility of evidence in a federal or a criminal case, a federal civil or criminal case. With expert witnesses, testimony that is not firsthand is hearsay, a statement other than the one made by a declarant while testifying at a trial or a hearing, and thus is inadmissible in court. The exception is for digital evidence, allowing an expert witness to provide his opinion during a trial or a deposition. Both defense and prosecution can use their own expert witnesses and can cross-examine the opponent's expert. Once again, the goal of the defense is to discredit the expert, the testimony, the evidence, the tools, and the scientific methodology used to gain concessions. Under the federal rules of evidence, all parties in the trial must disclose the witnesses they will use at a trial. An expert may bring his or her own exhibits to the trial. The federal rules of civil procedure apply to civil cases with expert witnesses. An expert witness must provide a written report to a trial. Disclosure of an expert witness is an important part of discovery. Those reports have to have a complete statement of all opinions, the facts and data, any exhibits that are going to be used, their qualifications, where they have already provided expert witness, and how much they're going to get paid for it. There's an actual rule for the hearsay stuff. It determines things that like emails, spreadsheets, system logs, and records created in the normal course of business are admissible in federal court. Digital evidence is not regarded as hearsay. Hearsay rule is applied differently to content created by a person versus content created by a machine. There is the best evidence rule. A secondary evidence or a copy is usually inadmissible in court when the original exists. This rule is exempt for digital evidence. As a reminder, under the Sixth Amendment, all defendants must be given the right to defense counsel. At the end of the day, if expert investigators lawfully and scientifically acquire evidence, or acquire incriminating evidence, and the findings are presented appropriately, the prosecution should be successful if the defendant is guilty. Can't forget the California Consumer Privacy Act. California residents have the right to request the removal of personal information, prevent the sale of personal information, and have the right to access their personal information from businesses. CCPA and other similar laws are important to be aware of, as they will determine what forensics data may be available and how it can be lawfully accessed. And now a quick look outside of the US. Apart from Ireland and the UK, the legal system of most European countries is based on Roman law, people property, and acquiring property. In Europe, the individual is afforded control over personal data. Employees need to be notified when an investigation of their computer will take place. A US investigator cannot acquire evidence from a computer and simply bring it back for analysis. Online privacy is an individual right in the EU. These differences can result in fewer results for investigators, and the environment should prove more problematic in the future. The General Data Protection Regulation, GDPR. This law has profound impact on digital forensics. It stipulates how companies or entities must handle records of EU citizens. Fines can be as high as 20 million euros or 4% of global annual turnover, and the law limits the amount of data a company can collect about a consumer. For example, a company can only collect personal data that is necessary to complete a transaction. It can't be used for another purpose or sold to a third party. A company must clearly state its privacy policy and data sharing agreement in full. The rights of the individual are the right to be forgotten, the access to their personal data, amend incorrect personal data, transfer data from one provider to another. GDPR makes a distinction between personal and sensitive data. Personal data can be name, email address, IP address, mailing address. Sensitive information counts as race, ethnicity, political opinions, religious or philosophical beliefs, trade union membership, genetic, biometrics, health records, and sexual orientation. GDPR also makes a distinction between a data controller and a data processor. Data processor is an entity that processes data for a controller based on a specific guideline provided by the controller. The controller essentially maintains that personal information. With all the limits on data collection and retention, a criminal investigator may have more limited access to personal information for corporations. If a US company has an employee in Spain whose laptop was stolen, it could be problematic to check if the laptop was compliant or encrypted. Local and GDPR legislation impact whether the investigation must take place in Spain, whether data can be transferred back to the United States, and permission be sought from the employee to investigate the laptop owned by the company. GDPR makes investigations more attorney-directed. The incident responder may have to seek advice from a cyber legal attorney, country legal, and the company's data protection officer during investigations. There's a bunch of more questions that have to be answered under GDPR. China has arguably the greatest restriction on internet content, and the government closely monitors the content that citizens view with the Great Firewall. In April 2011, India introduced the Information Technology Rules of 2011, which protects the privacy of online consumers. And it's important to know that this legislation impacts US companies that outsource services to India. Any questions? That was a lot. Any questions? Any questions? Okay. This week, get another case. Hooray. This time, there are no there's 4 questions to answer. But this is not a quiz as the prior 2. You have your case information. You have to answer these 4 questions, but this time you're making your first report. So you are submitting a PDF answering these 4 questions in your first case report. As always, because I will continue to reiterate it, you're not expected to work alone. You're not expected to do this just by yourself. It was not built to be done by an individual. Work together. You have Discord, which I see a number of you are using. Great job. Keep at it. Remember that you also have the AllDF channel, so you can speak with other people taking the same course, and that is perfectly fine. Any questions on this, on the work for this week? Yes, Austin, you'll type a report like some examples that were shown last week. This is your first one. There is no penalty on late submission. If you recall in the very first lecture, I said that we have a due date, but if and when life happens and you miss the due date, don't freak out. As long as you get it in by the due until date of May 18, 11:59 p.m., you won't get penalized. But yes, cover page, table of contents, all that shenanigans. Yep. Case 3 is your first case where you are submitting a report. This is making that mental transition from answering questions to copy paste into a quiz to begin writing reports. Because like I said, this is week 7, which means week 9 is when we begin working on the small and large cases, where it's just going to be reports. So we're making that shift over. Cool. Hope this was fun. I know it wasn't as technical as it usually is. And if there is nothing else, then I'll stop the stream.